Hi, my name is Amanda Rocha. I am an estate planning and probate attorney in California. Today I'm going to give you an example of what an estate plan might look like for someone who is in their 20s. Before I get into that, I want to give you my contact information. You can find me on my website, www.amandarocalaw.com. You can comment down below if this platform allows you to do that, or follow along on my social media. I'm at Amanda Rocha Law. So I recently made a video and podcast about what your 18-year-old might need, but if you're in your 20s or if you have children in their 20s and you're trying to figure out what an estate plan might look like for someone who has typically a more modest estate, this is the video for you. As I previously discussed, there are certain documents that everyone needs regardless of what their net worth is, regardless of what their assets look like. Those documents include an advanced healthcare directive, a durable power of attorney, and a HIPAA authorization. Those three documents together will protect you if something happens to you and you become incapacitated. It allows someone else to step in on your behalf, make decisions for you without having to go to court and get a conservatorship assigned. Because getting a conservatorship takes time, it costs a lot of money, and it's really hard to get a judge to take it away. Whereas when you have an advanced healthcare directive, a durable power of attorney, those two documents together can spring into action when you need someone to help you, and they can immediately go away as soon as you've regained your capacity. Other documents that someone in their 20s might need is a will. A will alone is not going to avoid probate, but if you have assets that do not total over $184,500, then you aren't so worried about avoiding probate at this time. What you should be worried about really is what happens to your property when you pass away. If you don't have a will and you pass away and your property does not reach the probate threshold, then your loved ones are going to have to use an affidavit stating that they do not believe your estate needs to go through probate, and try and use that affidavit to collect your personal property either from the bank or whatever it is. That document is there for a reason, but it is not the most efficient way to handle things, and I've seen a lot of institutions give people problems because of that document. If you had a will, on the other hand, even if probate's not necessary for you, using that will as a tool to collect your personal property is a lot easier for the people who are cleaning up after you've passed away. You may have a child or children. If you do, then a guardianship declaration is necessary. If something happens to you, what happens to them? You want to make sure that they go to the people that you believe would be the best guardian and not who the court believes to be the best guardian. If you own property, if you have a house or land, then a trust, a revocable living trust, might be necessary in order to avoid probate. Otherwise, just make sure that your beneficiary accounts are up to date, and that if you have a 401k, a life insurance, or anything like that, an IRA, that your beneficiaries are listed as to who you want them to be. And if you need to change those, you can change them at any time that you want. Just do not list your estate as the beneficiary, because then probate might be triggered. If you have questions about this or something that I didn't mention, an asset that I didn't mention, please comment down below. You can also follow along on my social media and make a comment there, or send me a direct message. I'm at Amanda Rocha Law, or schedule a strategy session with me on my website, www.amandarocalaw.com. Thank you.